Hi, everybody. Hope you'll excuse me for a few minutes while I do a little sharing. And I'd like to ask you to also do a little sharing of this video. Thank you. Hey, Steve. How are you doing? Thank you for sharing. Hi, Dolores. Hi, Greg. Hi, Cheyenne. Nice to see you. Thank you all for coming. It's great to see you here. So, did anybody watch the Bernie rally in Venice today? I hope you did. I certainly did. Okay, here we are. Hi, Greg. Hi, Dolores. Hi, Cheyenne. Hi, Kay. Hi, Dale Weaver. Hi, Steve Wolf Brand. And Russ Gallman. Hi, how are you? And Steve said, apparently our revolution is here, is real, brought tears to my eyes. AOC, we can win. Yes, I thought ANC, AOC was looking very presidential already. I found myself thinking, boy, 2028 is her time. Maybe 2024. No, I guess she'll still be too young then. Kay says, hey, Joe, glad to see you. Don't have to listen to Maddow now. Oh, Lana says, I'm competing with Bernie. Well, I had a wonderful time actually watching Bernie in Venice. Sent you a comment on Messenger 10 minutes ago, re a JD episode. Okay, thanks, Cheyenne. After the live stream is over, I'll certainly take a look at it. Steve says, I think we are winning. Yeah, I think we're winning too. I mean, after the wonderful performance and the debate and the reactions, but thereafter, almost everybody is ready to concede that Bernie certainly won. There was that program, the focus group. Has everybody seen the YouTube on the focus group where the Republican, extremely well known um, extremely well known Republican pollster and master of focus groups, but did a focus group YouTube on the debates, and he found that there were very few people who thought that either Biden or Buttigieg or Klobuchar uh, actually won the debate. 14 people thought that Bernie won. 9 people thought that Warren won. 3 people thought that Yang won, and everybody else in the focus group was shut out. We got 0 people who thought that they won the debate. So Bernie dominated, in this one, and he's come off it really raring to go. He was very, very fiery, very much on fire in California today. He was hitting on every major theme of the campaign. It was very exciting. Had a very big crowd. In Venice was 15,000. So Kay says massive crowd at the Bernie rally. Which Bernie rally was this, Kay? Was it the one in Venice? Okay, says can't hear me too well. Are you still having trouble hearing me today? Okay, let me know, please. Dale says it sounds fine. Steve said, nobody invites me to wine caves. Nobody invites me to wine caves either. I guess that's because neither you nor I are billionaires. And Greg thinks that Mayor Pete and Amy ought to drop out. Yes, I agree. They have to drop out. Kay says very low volume here. I'll turn my volume up a little, Kay, and maybe that will help. I don't want to turn it up too high though because I get into echoes then. But we'll see if we can get it just right. How about that? Okay, I see you're all very energetic tonight. Yeah, the Venice rally. I heard that was estimated at 14,000. But if you say 20,000, I'm certainly ready to believe you. And Steve says it was the best speech from Bernie ever. Kay says sounds a little better. Well, I can turn it up still further. Just tell me if there's an echo. That's all. Okay. Let's go to Joe's Wine Cave. We can have a blast. Yeah. Yeah, the wine cave is going to be a main theme for the campaign. Russ says the sound is fantastic tonight. Thank you, Russ. That's great. Okay, let's get into the topic, shall we? It asks the question about whether there's a constitutional crisis. I think there is. The reason why there's a constitutional crisis is not the impeachment, okay, of Donald Trump. There is a provision for impeachment of the president, okay, that's in the Constitution. So, it is certainly the case then that impeachment is constitutional. That's not the cause of the constitutional crisis. The cause of the constitutional crisis is one of the articles of impeachment, and that article is charging Trump with obstruction, okay, of Congress because Trump has been blocking all their subpoenas. He has issued a blanket block, simply ordering people in the executive branch not to collaborate with the Congress, and so that is certainly certainly the beginning of a constitutional crisis. So Congress has chosen the instrument, okay, of impeachment to try to get over the block. In other words, the ability of the executive to have, okay, its oversight over the executive branch is something that's been recognized as a duty of Congress actually since the beginning of the Republic and is in the Constitution. It's always been recognized by the courts that in order to exercise, okay, its oversight, that Congress has the power of investigation of the executive branch, including the power to subpoena all the officials in the executive branch, including the President of the United States. Now, there is an executive, there is a privilege doctrine that comes down from common law, okay, in England. Okay, it's very ancient, and it basically says that there are privileges, okay, of privacy which the executive has under our Constitution, so that the power to investigate and the power to subpoena that Congress has is a power that is balanced off in some way by the need for the president to have some privacy insofar as uh, the considerations, okay, and the deliberations and the internal processes of the presidency are concerned. But that has never been interpreted as an absolute right of the executive, okay, to deny the powers, okay, of investigation to the Congress. Therein lies the crisis, the constitutional crisis that we are seeing right now, because Trump appears to be claiming an absolute power okay, to deny Congress the tools it needs to investigate what the executive branch, okay, is doing. That was the meaning of the obstruction, okay, of justice charge that forms one of the two articles of impeachment of the president that just was voted by the House, okay, a few days back. So let us go now to some articles dealing with these particular subjects. Okay, let me get to the first of these. And the first of these, okay, is not, okay, an article, but rather it is the actual text of House Resolution 755, which is the resolution impeaching Donald John Trump, President of the United States, for high crimes and misdemeanors. And okay, what I want you to see here is that the first article of impeachment, okay, the abuse of power article, notes that constitutionally the House of Representatives shall have the sole power of impeachment, and the President shall be removed from office on impeachment for and conviction of treason, uh, but, 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 treason, bribery, or other high crimes, okay, and misdemeanors, unquote. And the House concludes in that article that Donald J. Trump has abused the powers of the presidency in that, okay, and then it outlines uh, in a paragraph which I will not read the specifics involving the solicitation of the interference of a foreign government, okay, specifically the Ukraine government um, in the presidential election process of 2020. Now, I think by now you're all familiar with this particular story. I'm not going to go through this story. What I want to point out here is that it seems as though the abuse of power, that first article, has been tied specifically to the Ukraine situation. Congress concludes the paragraph on the abuse of power of the president by saying, in so doing, President Trump used the powers of the presidency in a manner that compromised the national security of the United States and undermined the integrity of the democratic process of the United States, and that he thus ignored and injured the interests of the nation. And then it mentions, of course, the solicitation with respect to the government to publicly announce investigations into former Vice President Joe Biden Jr. And also a discredited theory promoted by Russia, which alleged, okay, that the Ukraine, rather than Russia, interfered in the election in 2016. And then, of course, it goes into the claim that the aid was withheld, okay, from the Ukraine by Trump until, okay, he got agreement from the new president of the Ukraine that he was going to announce an investigation, okay, by Joe Biden. Now, there are a lot of disputes over these particular details. I'm not going to say that the House, okay, is necessarily right with respect to this article. Uh, okay, I think the House is probably right, but I think the argument is more complicated than what is given here in the articles, okay, of impeachment. And so I think Article 1 is highly disputable and easily propagandized against by the Republicans. And I also think that, okay, it's not obvious to people without studying the issue carefully for them to decide that the House of Representatives is certainly right, okay, in this respect, and that there was a solicitation. Uh, Moving to the second article on the obstruction, okay, of Congress, that deals directly with the claims of the president to deny Congress the right to subpoena employees of the executive branch of Congress to come and to testify. Uh, and the House says President Trump has abused the powers of his high office with the following means: one, directing the White House to defy a lawful subpoena by withholding the production of documents sought therein by the committees. Two, directing other executive branch agencies and offices to defy lawful subpoenas and withhold the production of documents and records from the committees, in response to which a Department of State, the Office of Management and Budget, Department of Energy, Department of Defense refused to produce a single document or record. Now, that charge, that second point, the Congress is certainly right about that. No president has ever claimed, as part of a privilege claim, which, by the way, the president has not made here, but it has never been held that the departments of the executive branch, the heads of which are confirmed by the Congress, that they can be part of a privilege claim from the executive branch. In other words, executive privilege has always been thought, insofar as it applies at all, to apply only to the discussions of the president with the closest of confidants of the president inside of the executive branch. In other words, the president's personal staff and the attorneys of the president. And how far that privilege extends is under dispute and has always been under dispute. Whether a chief of staff like John Michael Mick Mulvaney, Robert B. Blair, John A. Eisenberg, whether staff like this, okay, the specific staff named here, it has always been under dispute and under debate and unsettled whether people having positions like that are able to legally defy subpoenas that come from the Congress. Congress has always claimed, no, the privilege is not there The executive branch officials have sometimes claimed, well, yes, that privilege is there, but insofar as they have claimed that, it's been based on the right of privacy, which the president is supposed to have. And very often in the past, that right to privacy, that assertion of the privilege of the executive, was denied in the end by the Supreme Court when things went to the Supreme Court. Now, so far, things have not gone to the Supreme Court. The reason why being that Nancy Pelosi simply thought, well, we can impeach him if we want to. That's within the purview of the House, of Representatives. It's not a good thing for us to allow him to delay and delay and delay, and delay for various reasons, including political reasons. Therefore, we're going to avail ourselves of our privilege under the Constitution, and we're going to claim that since he didn't make a formal claim of privilege that was limited in any way, but simply ordered people to resist and not comply with the subpoenas, we're just going to impeach him for that. Now, it's my opinion. I studied constitutional law. I'm not a lawyer, but I studied constitutional law. It was one of my best subjects, in graduate school, as it happens, And I've studied constitutional questions actually all my life since then, and the way the courts have decided these things. And I am saying to you that kind of broad and general power to deny Congress the right to investigate through issuing subpoenas to employees of the executive branch of government, that kind of claim is unconstitutional. That kind of order is unconstitutional. The House is absolutely right with respect to Article 2. It is absolutely right. And it is sufficient in itself to impeach this particular president and to convict this president in the Senate. Because objectively, the president has certainly violated the Constitution here in a very serious way by not allowing the House to investigate. The House says this abuse of office served to cover up the president's own repeated misconduct and to seize and control the power of impeachment, and thus to nullify a vital constitutional safeguard vested solely in the House of Representatives. Yes, this is definitely true. The House may be wrong about the Ukraine. The president may be right about that. But whether the president is right or wrong about that does not give the president the right to deny the witnesses to the House of Representatives. That is unconstitutional conduct of a very serious order, because it implies that the president can do what he wants in secret, and the House cannot uncover that. That gives the president dictatorial power by itself. It is certainly unconstitutional. It is certainly an abuse of power in itself. It is certainly a high crime and misdemeanor. It certainly fits in with that concept in the Constitution. Now, to finish here, in all of this, President Trump has acted in a manner contrary to his trust as president and subversive of constitutional government, to the great prejudice of the cause of law and justice and to the manifest injury of the people of the United States. Yes, and where lies the injury? The injury lies in the denial of democratic process to the people of the United States. The Constitution guarantees the right, the right of the House, the right of the Congress to investigate the president as part of the oversight rights. Okay, and the ability to uncover key information to allow the people of the United States to evaluate the performance of the president. That is an injury to the democratic process and therefore to the people of the United States. Wherefore, President Trump, by such conduct, has demonstrated that he will remain a threat to the Constitution if allowed to remain in office, and has acted in a manner grossly incompatible with self governance and the rule of law. President Trump thus warrants impeachment and trial, removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Truer words, friends, were never written than the words in this final paragraph. These words are true. And they're beyond any considerations of pragmatism here. He does remain a threat to the Constitution. How does he? Because if his claim to have the ability to deny Congress its right of oversight is sustained in this process, then that will make Donald John Trump a dictator in the United States. It will make him a dictator. And the Constitution prohibits dictators. The Constitution prohibits dictators. It prohibits tyrants. A dictator and a tyrant are the same thing. What Donald Trump is claiming by denying Congress the right to investigate the affairs of the executive branch, which Congress funds under the Constitution. What Donald Trump is claiming there is he is claiming the right to be a dictator. That's the right that he is claiming. We must not forget that. And we must always deny that particular right. Now let's get to some of the other articles, or some of the articles. That wasn't an article. Two articles of impeachment, but it was not. It was not an article from a publication other than the Congressional Record. This is Truth Out. And this one is by Marjorie Cohn. It says, "No, McConnell, biased jurors and no witnesses do not make for a fair trial." And let's go through this one, which was written, when was it written? December 21st. Why, that's today. In Truth Out. And Marjorie Cohn is an attorney and a very good student of the Constitution. In my decades as a criminal defense attorney, I have never seen a trial where the jurors admit they aren't impartial, coordinate the trial process with the defendant, and then, as promised, find the defendant not guilty. And yet, that is exactly what Senate Majority Leader Mitch McConnell proposes to do, aims to do, she said. But basically, it's what he's proposing to do and what he will do unless there are very, very strong protests against this. Now, one thing we have to notice just from this first paragraph, what the House was doing was indicting Donald John Trump. The impeachment by the House is an indictment. It is not a trial. As an indictment, it doesn't have to be impartial. Yes, it would have been nicer if the House was more fair, if it allowed more time for the Republicans, if it allowed them to stretch out the process of impeachment for a long, long time, as long as they wanted to, as long as they needed to make their case. However, that is not a requirement in the Constitution. It is not a requirement of the Constitution. The House's function is to indict. As such, its committees can be biased. Their rules can be biased. The House can be biased. The indictment can be biased. Just as prosecutorial indictments in the United States every day are biased and reflect the opinion of the prosecutor and the processes of the prosecutor. Now, of course, there is a grand jury that indicts criminals. Yes, there is a grand jury. However, the grand jury proceedings are generally not impartial. As the saying goes, the prosecutor can usually get a grand jury to indict a ham sandwich. It's expected, though it may be regrettable, that grand jury proceedings will not be entirely objective. The objectivity we rely on in the criminal courts and in the civil courts is to be obtained in a trial where both sides are able to argue their case. This, however, is not a criminal case anyway. It has analogs to a criminal trial, but it's basically a civil proceeding relating to the removal of the president from office, not to a verdict that the president is a criminal, and has nothing to do with any criminal punishment of the president. It's a civil proceeding about whether the president is fit for office. So we have to recognize that. And we have to recognize that while the House, like a prosecutor, has the right to make unfair judgments and, in a certain sense, to be partial, and to come up with an indictment which is partial and which is unfair. The Senate is charged by the Constitution to run a trial where the jurors are supposed to be open-minded and impartial and take oaths to function that way. They take an oath. They have to swear on the Bible. Every member has to swear or affirm their objectivity and their open-mindedness. Every member of the Senate, including Mitch McConnell, including Lindsey Graham, including every Democrat. So, the proceeding in the House is different from the proceeding in the Senate. It's not like two trials in two different bodies. What went on in the House is not a trial. What goes on in the Senate is supposed to be a trial. That's the second stage. That's the trial stage. It has to have different rules than the rules we saw in the House, and a different process. Going on with the article, negating any semblance of conducting a fair trial. Senator McConnell has brazenly declared his intention to violate the senator's oath of impartiality and deny the right to call witnesses to testify at the Senate trial on the articles of impeachment. Okay, now, no. Okay, what's going on is, if he violates his oath of impartiality, and it can be proved, he himself could be impeached. Now, of course, there's no realistic prospect that he'd be impeached by a Republican Senate, which has elected him as the majority leader of the Senate. That's not going to happen. But were the Democrats to take over the Senate in 2021, and they decided to investigate the actions of Mitch McConnell, and he goes through as his threat to be partial, obviously partial in this particular trial, then the Democrats would have grounds on which to impeach Mitch McConnell and end his term in the Senate, on grounds that he perjured himself when he took the oath. He can't do that. Anyway, he was going to violate his oath of impartiality and deny the right to call witnesses to testify at the Senate trial on the articles of impeachment. It's no wonder that the leaders of the House of Representatives are waiting to transmit the articles to the Senate until they receive assurances that the senators will hold a fair trial. Now, there's nothing in the Constitution that says the House of Representatives cannot wait to transmit the articles to the Senate. Nancy Pelosi is quite within her rights to do that. Now that the House has voted to impeach Donald Trump for abuse of power and obstruction of Congress, the decision about whether to convict Trump and remove him from office will be made by the Senate. But that trial will be a farce and a sham if the majority of the Senate refuses to provide basic guarantees of fairness. Now, that is an absolutely true claim. That may have something to do with Marjorie Cohen as that she's a Democrat. It might have something to do with her being a partisan. But just because somebody's a partisan doesn't mean that they're not telling the truth. if those senators violate the oaths that will be put to them when that trial in the Senate starts, then that trial will be a farce and a sham. The Senate has to provide the basic guarantees of fairness because the senators are the jurors in a trial. All the senators are. And the Democratic jurors have a perfect right to call on the rest of the jurors for fairness all through the trial. Anyway, the Minority Leader Chuck Schumer and McConnell are at loggerheads over how to proceed with the trial. Schumer sent a proposal for ground rules, modeled on those used during the Clinton impeachment, to McConnell. Schumer requested the trial begin on January 7th, that each side have a time limit, to present its case. Now, Clinton lived by those rules. He lived by those rules. And his impeachment was turned aside. He was declared not guilty under these very rules. Why aren't these rules good enough for Trump? Why aren't they good enough for Trump? I mean, that's what I want to know. Obviously, what Clinton was facing was a partisan Republican impeachment, which is what he got. He got that in the Monica Lewinsky case. He never would have been impeached if it were up to the Democrats. He was impeached by the Republicans in the House, and it was a totally partisan process. No Democrats wanted to impeach him there because he lied about an extramarital affair. Even if he lied under oath, they didn't think that was serious enough to impeach him because they didn't think that endangered the democratic process in the United States. Anyway, Schumer requested the trial begin on January 7th, that each side have a time limit to present its case. Perfectly fair. He asked that 4 witnesses with direct knowledge of the facts be called to testify for a maximum of 4 hours each. Perfectly reasonable. Acting White House Chief of Staff Mick Mulvaney, former National Security Advisor John Bolton, Mulvaney's senior advisor Rob Blair, and Michael Duffy, the Associate Director of National Security at the Office of Management and Budget. All 4 refused to appear in response to subpoenas from the House during its impeachment inquiry, which was one of the reasons for the impeachment, one of the bases on which the House impeached Trump for obstruction of Congress. McConnell rejected Schumer's proposed witnesses, stating that it is the House's duty to investigate and the Senate will not volunteer for a, quote, fishing expedition, unquote. That is ridiculous. That is ridiculous. Trump has been impeached for obstruction of the subpoenas of the House. Those subpoenas were delivered to those members of the executive branch. They refused to appear in response to the subpoenas. They are vital witnesses because they need to testify that they received the subpoenas and that on orders of their superior, the President of the United States, they refused to appear in response to the subpoenas. They need to be questioned themselves as to whether they think it's the constitutional right of the Congress to present them with subpoenas and to command their presence before Congress. They might themselves actually believe that Congress had every right to do that. But they did not comply with Congress because they felt they were under the authority of the president. It would be useful to know if that was the opinion of these people. It would be important, okay, to know that. It is not a fishing expedition. They are witnesses to the obstruction of Congress charge. Trying to get them there to testify is not a fishing expedition. Also, some of them were aware of the proceedings around the key phone call that was the trigger event for the Ukraine dispute. They might well have vital testimony which is relevant to Article 1 of the impeachment as well. They are witnesses which the House, whose presence the House was not able to command. If the Senate, however, subpoenaed them under the authority of the Senate, that would not be a fishing expedition. Then they might have to appear. Speaking on the Senate floor the day after the House passed the articles of impeachment, Senator McConnell referred to the House impeachment inquiry as a, quote, slapdash process, unquote, calling it, quote, the most rushed, least thorough impeachment in modern history, unquote. He accused Speaker of the House, Nancy Pelosi, of wishing that, quote, the Senate should supplement House Intelligence Committee Chairman Adam Schiff's sloppy work, unquote. That may be, but that is not the business of Senator McConnell. It is not. For better or worse, the House has impeached. Whether the process was slapdash or not is not relevant. What's relevant is the outcome in the articles of impeachment and whether the president is guilty of the charges in those articles. That is all that is relevant. The internal processes of the Senate in arriving at the indictment. The internal processes of the House, okay, in arriving at the indictment are literally not the business of the Senate. That is up to the House. It has the sole power, okay, of impeachment. Now, the Senate has the sole power of conviction, but according to the Constitution, that power has to be rendered through a trial. And trials have to be impartial under the Constitution. They cannot be slapdash. They cannot be travesties. They cannot be sloppy going on. But Trump took actions that denied the House committees valuable evidence. In an unprecedented move, Trump ordered all executive branch employees to defy committee subpoenas and refuse to testify in the impeachment inquiry. He also refused to turn over any subpoenaed documents, another contrast with prior impeachments. Trump asserted that subpoenaed witnesses who declined to testify would receive, quote, absolute immunity, unquote, from criminal or civil prosecution. He cannot assert that. He cannot assert that. I mean, those subpoenaed witnesses are in contempt of Congress. If Congress wants to declare them in contempt, he doesn't have the power to pardon them for contempt of Congress. That goes beyond the power of the executive branch. His assertion is not true and is further unconstitutional, and it is the assertion of a dictator. That doctrine is a creation of the Department of Justice's Office of Legal Counsel. No court, statute, or constitution has ever recognized it. Marjorie Cohn is completely right about that. No court, statute, or constitution has ever recognized it. 9 witnesses followed Trump's order and refused to testify. Nevertheless, 17 witnesses provided depositions, and 12 witnesses testified in the House proceedings. They were members of the Trump administration, and they provided overwhelming evidence of Trump's impeachable conduct. Well, I don't know if I would say that, okay, or if I agree to that. The Republicans did not find it overwhelming, and they have a lot of arguments, okay, against that. And I don't know that the public has agreed that there was overwhelming evidence of his impeachable conduct with respect to Article 1. But with respect to Article 2, the obstruction of Congress, there is overwhelming evidence. It is the evidence that the 9 witnesses followed Trump's order and refused to testify, and the evidence that Trump gave the order. Then Marjorie Cohn points out the article of obstruction of Congress was based on Trump's blanket refusal to provide documents and allow subpoenaed witnesses to testify before the House of Representatives, to whom the Constitution grants, quote, the sole power of impeachment. If witnesses are not allowed to testify at the Senate trial, it, quote, would be the first impeachment trial in history that heard no witnesses, unquote. Schumer stated on the Senate floor in response to McConnell's remarks. The Senate has never prevented House managers from fairly prosecuting their case, quote, unquote, but Schumer added. If, as McConnell insisted, the House's case for impeachment is so weak, why is he, quote, so afraid of relevant witnesses and documents, unquote, Schumer asked. All 4 proposed witnesses are top Trump officials, and Schumer said he doesn't even know if their testimony would incriminate or exculpate Trump. And he doesn't. And none of us know that. They might well exculpate Trump in relation to Article 1 of the impeachment. Of course, they cannot exculpate him with respect to Article 2, because the fool ensured that Article 2 is valid. McConnell favors a pro forma trial with no witnesses that leads to a rapid acquittal of Trump. Yes, of course. He doesn't want this interfering with the elections. I think a lot of the Democrats don't want it interfering with the elections either. Maybe that's why Nancy Pelosi went through a slapdash process, because she wanted to get rid of the impeachment. She never wanted it in the first place. She didn't want it to interfere with the elections in the fall of 2020. On Fox News, McConnell told Sean Hannity there was, quote, zero chance, unquote, Trump would be removed from office. Well, that's certainly an extremely biased statement. Now, I wonder how compatible that is with McConnell taking the oath he must take as a juror. He pledged total coordination, quote unquote, with the White House and Trump's defense with the defense attorneys for Donald Trump. The senators who will sit as jurors at the trials must take an oath of impartiality. However, McConnell didn't even pretend to be impartial, declaring, quote, "I'm not an impartial juror. I'm not impartial about this at all," unquote. Can we sequester the jury? Can we sequester the Senate? I'm afraid I don't think so. But since we can't sequester the Senate, and since the proceedings of the Senate are open to everyone to see, we'll be able to tell whether Trump is an impartial juror or not. I'm sorry, whether McConnell is an impartial juror or not. And if his behavior is such that it's clearly not impartial, he'll be open to impeachment at a later time. What does a fair trial require? To have a fair trial, both sides must be allowed to subpoena witnesses and documents. The prosecutors, the House managers, as well as Trump, should be permitted to call witnesses and present documentary evidence. McConnell seeks to violate that right. Harvard law professor Lawrence Tribe, Larry Tribe, okay, who was Obama's professor for a while, just so you know, who has advised the House Judiciary Committee during the impeachment inquiry, thinks the House can leverage its power over the timing of the transmittal of the articles to the Senate. Who knows, maybe the idea first came from him. Quote, "It would be justified to withhold going forward with a Senate trial," unquote, he wrote in the Washington Post. Quote again, "Under the current circumstances, such a proceeding would fail to render a meaningful verdict of acquittal. It would also fail to inform the public, which has the right to know the truth about the conduct of its president," unquote. Tribe tweeted, quote again, "Schumer's proposal to McConnell, if he rejects this reasonable ground rules and insists on a non-trial, the House should consider that as a breach of the Senate's oath and withholding the articles until the Senate reconsiders," unquote. After the House voted for impeachment, Nancy Pelosi told reporters she would hold the articles back until it became clear there would be a fair trial in the Senate. Quote, "We'll make our decision as to when we're going to send it when we see what they're doing on the Senate side," unquote. She said, quote, "So far, we have not seen anything that looks fair to us," unquote. Well, you haven't seen anything yet, right? The rule accept a bunch of loose statements by a bunch of loose cannons. The rules adopted by the House require a separate vote to give Pelosi the green light to appoint House managers and send the articles to the Senate. Well, that may be the rules of the House, but after all, Pelosi can change the rules of the House just like that, right? A sizable number of Democratic House members support a delay in transmitting the articles to the Senate while they determine whether the Senate trial will be fair. Well, that's interesting because if generally speaking, the majority support a delay, if all the Democrats support a delay, then the rules of the House aren't going to change. And so they won't be transmitting the articles to the Senate until they determine whether the Senate trial will be fair. Now, the question is asked, is transmittal of articles necessary to complete the impeachment process? Some Democrats argue that the House should never send the articles to the Senate, okay, to deny Trump an acquittal. But Noah Feldman, also a Harvard law professor, who testified at the House Judiciary Committee hearing without citing any authority, maintains that impeachment is not complete until the House transmit the articles to the Senate for trial. Now, there's nothing in the Constitution about that. So he's interpreting it. But what he says is impeachment, unquote, under the Constitution, means the House sending its approved articles to the Senate, with House managers standing up in the Senate and saying, "The president is impeached." He wrote in the the Bloomberg opinion. I wonder if that's an unbiased support source, since Bloomberg, of course, is now running for the presidency. Quote: If the House does not communicate its impeachment to the Senate, it hasn't actually impeached the president. Unquote. Feldman asserted. If the articles, quote, if the articles are not transmitted, Trump could legitimately say that he wasn't truly impeached at all. But Georgetown professor, um, but Georgetown law professor Marty Lederman disagrees with Feldman. He asserts that by adopting House Resolution 755, the House effectively impeached Trump. That resolution says, quote, Donald John Trump, President of the United States, is impeached for high crimes and misdemeanors, unquote. Although the House adopted each article separately, House rules provide that the adoption of the resolution as amended shall be divided between the two articles. Moreover, House impeachment rules state, quote, the respondent in an impeachment proceeding is impeached by the adoption of the House of Articles of Impeachment, unquote. Furthermore, and the House has the sole power of impeachment, by the way, so its rules are the rules that count, not Noah Feldman's opinion. Furthermore, Pelosi declared at a news conference the day after the impeachment that the articles adopted by the House make Trump's high crimes and misdemeanors, quote, an established fact, unquote. Not simply probable cause that Trump committed abuse of power and obstruction of Congress. I don't think I agree with that. I think that the articles adopted by the House make the indictment of Trump for high crimes and misdemeanors an established fact. It's up to the Senate to convict. It's the Senate's sole right to try and convict, not the House's. So it's the Senate that will make that an established fact if it so chooses. Regardless, however, Feldman admits that the Constitution does not prohibit a delay by the House in sending the articles to the Senate. Thus, even if one were to accept Feldman's arguments, the eventual transmittal of the articles will complete the impeachment of Trump. After a brief meeting, McConnell and Schumer were unable to agree on a process for the trial. The Senate will recess for the holiday break and return January 3rd, but won't make decisions about the trial rules until January 6th. Although it requires 67 senators to convict and remove a president, procedural decisions such as establishing trial rules require only 51. That is correct. Since there are 53 Republicans in the Senate, the reason for that, by the way, is that the Constitution says it requires 67 senators to convict. So the Senate, for its internal procedures, cannot change the Constitution. Okay. But the Constitution also says that the rules of the Senate and the rules of the House are up to each body. And these bodies are governed, in making the rules, they're governed by majority rule. Since there are 53 Republicans in the Senate, 3 could defect and vote for rules acceptable to Democrats. That's true. Those most likely to buck their GOP colleagues are Senator Susan Collins of Maine, also Lisa Murkowski, of Alaska, and Mitt Romney, of Utah. Meanwhile, Trump remains an impeached president who cannot yet brag that he's been vindicated by the Senate. Now, I think that's absolutely true. He doesn't get a vindication by the Senate until there can be a trial in the Senate. And if the people in the House insist that the trial in the Senate has to be a fair trial with every senator abiding by his or her oath, then uh, if Trump avoids a conviction, he will be able to brag that he's been vindicated by the Senate, but not in the present circumstances. So let's consider for a minute. Okay, let's consider what is the implication of this? Okay, and I'm not saying here or trying in any way to say here that this was Nancy Pelosi's plan all along. I don't credit her with that kind of foresight or that kind, okay, of Machiavellian ability to plan, though people in the mainstream press always tout her great ability for strategy, okay, and tactics and playing 12-dimensional chess. They like to assume politicians can play 12-dimensional chess. However, let's consider the objective situation at this point. Trump cannot get a vindication from the Senate as long as the impeachment papers do not go to the Senate and as long as the prosecutorial team has not been appointed by the House. And this will not be done. This will not be done until the papers are sent to the Senate. It all has to be done simultaneously because the papers have to be presented by representatives of the House who go there and who declare Donald John Trump, the President of the United States, is impeached in a public statement. So, we have an impasse. What does an impasse mean? Before I go on to the next article, okay, I want to consider what an impasse means. What it means is that Nancy Pelosi has something to hold over Trump's head. Okay, now you may say, well, Trump doesn't care about that. I mean, he'll just go along and he'll propagandize and he'll say, well, Nancy Pelosi never sent it up to the Senate because they had a weak case in the House and they knew it was going to be turned aside by the Senate. So I am vindicated. Yeah, he can say that all he wants. The Senate can say that all he wants. But at the same time, okay, the Democrats will be saying, no, that's not true. He wasn't vindicated in the Senate because the Republicans were not willing to run a fair trial. But apart from that, this impeachment hangs over Trump's head. He's been impeached for abuse of power and obstruction of Congress. What happens if he keeps on obstructing Congress? If he keeps on denying subpoenas? I mean, the subpoenas have not ended with this impeachment. The investigations have not ended with this impeachment. The House and Pelosi are going to keep up the pressure on Donald John Trump. They're going to keep on calling for those witnesses. They may declare those witnesses in contempt of Congress. There are still cases that could go to the Supreme Court, that could go to the judiciary. In other words, this could hang fire with the Democrats refusing to send it up to the Senate. but going ahead with contempt of Congress proceedings for the witnesses, which then trigger cases in the Supreme Court. So let's look at another article. This is from Truthdig, and it appeared on December 17th, and it titled, "It's Now or Never for John Roberts." And it was written by Bill Blum, who's a contributor to Truthdig, a long-time contributor to Truthdig. Okay, and what Bill points to is that Supreme Court Chief Justice John Roberts has issued a biting reply in November 2018, I should say. Donald Trump had blasted a federal jurist as an Obama judge, quote unquote, for returning his new restrictions on political asylum. And Chief Justice John Roberts actually replied to Trump in a statement in the Associated Press and said, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them. The independent judiciary is something we should all be thankful for." Unquote. Trump, of course, issued a snarky rejoinder, and Bill Blum is saying here, "I'm sorry too, Mr. Chief Justice, but I also believe that in general there are significant differences between judges appointed by liberal and conservative presidents. This is especially true of justices who sit on the Supreme Court." And of course, then he points to the academic research on the ideological alignment of Supreme Court justices, which we have seen for many, many decades now, and increasingly during the period since 2000. It's more and more ideological, and it's more and more predictable what decisions of the Supreme Court will be based on the political leanings of justices. Okay, there's less and less unpredictability on the court. The more of these Federalist Society conservatives get appointed to the courts. Okay, Gorsuch, Kavanaugh, if I'm not mistaken, Clarence Thomas, but also Sam Alito and John Roberts are all Federalist Society justices. All learn their doctrine, which is extremely conservative, all learn their fundamentalist doctrines there. So Bill Blum says, "I'm willing, however, to be proved wrong. And by the end of the Supreme Court's current term, John Roberts, who is now the court's most prominent swing voter, the only one who, as far as we know, has any chance of voting with the four Democrats, he will have an opportunity to do just that when he and his colleagues decide three cases that could determine whether Trump is immune from both congressional and state oversight." Now, this is obviously relevant to the charge of obstruction of justice in this impeachment proceeding. There's the case of Trump versus Vance, which deals with the constitutionality of subpoena issued by a New York grand jury demanding the production of nearly 10 years' worth of the president's financial papers and his tax returns. Is Trump versus, probably Mazars, concerning a subpoena issued by the House Committee on Oversight and Reform to the president's accounting firm, requesting a variety of Trump's private financial workers, and Trump versus Deutsche Bank, concerning a subpoena issued by the House Financial Services Committee syncing similar records from Deutsche Bank and Capital One, the president's two favorite lenders. In each of the cases, lower courts ruled against the president. So the judicial holdings so far have ruled against the president, saying to the president, you need to stop standing in the way of these subpoenas. The Supreme Court, however, was under no obligation to review any of them, but agreed on December 13th to review all of them at the request of the president. Although the Supreme Court could find a way to resolve the cases on narrow grounds, the cases have the potential to redefine both the separation of powers between Congress and the president and the distribution of authority between the federal government and the states. The court could also use the cases to overturn or distinguish and restrict the long-standing precedents on executive privilege and presidential immunity established in United States versus Nixon, 1974, and Clinton versus Jones in 1997. Both the Nixon and Clinton cases were the products of investigations similar to the current undertaking to impeach and remove Trump from office. In Nixon, the court ordered then President Nixon to turn over clandestine White House audio tapes to Watergate special counsel Jaworski, rejecting Nixon's invocation of executive privilege. In the Clinton appeal, the court held that a sitting president is not immune from civil civil litigation that was initiated by a private party in federal court for acts done before taking office and unrelated to his official duties as president. Impeachment, the court noted, is the federal remedy for addressing a president's public misconduct. Trump has made his position on an expansive executive power unmistakably clear from his earliest days in office, speaking at the Turning Point by USA Teen Student Action Summit in Washington, D.C. in July. He famously claimed that under Article 2 of the Constitution, which sets forth the power of the presidency, quote, I have the right to do whatever I want as president, unquote. If anybody believes that, they're crazy. While the mastery of the Constitution by Donald Trump is meager and often downright embarrassing, the views of his primary legal advocate, Attorney General William Barr, are well developed and dangerous. As I explained in a previous Truth Dick column, Barr is a leading proponent of the unitary executive theory developed by right-wing legal scholars in reaction to the ouster of Nixon. The theory dates back to the presidency of Ronald Reagan. It asserts, as University of Baltimore law professor Garrett Epps has explained, that because the Constitution vests the executive power in a single president, any attempt to limit the president's control over the executive branch is unconstitutional. And that, of course, is a ridiculous theory because the Constitution also specified various ways in which the three branches were able to balance each other. So it gave the Congress certain powers to hold the executive branch in check. That is such well-established constitutional doctrine that it is mind-boggling that any lawyer would claim that any attempt to employ the checks of one of the other branches given to those branches by the Constitution is invalid, and that the president can deny any attempt to limit his control when checks like that are involved. Impeachment is in the frickin' Constitution in its more robust iterations. The theory goes even further, verging on a platform of presidential supremacy, as Professors Carl Mannheim and Alan Itis of Loyola Law School in Los Angeles observed, off-quoted 2006 academic paper. In its stronger versions, it embraces and promotes a notion of consolidated presidential power that essentially isolates the executive branch from any type of congressional or judicial oversight. I'll tell you what else it does. Okay, what else it does is it gives the president the power to overrule what the Federal Reserve does. Because in making the Federal Reserve an independent entity, independent of the rest of the executive branch, the implication of the unitary theory of the presidency is that Congress overstepped its powers because the activities of the Federal Reserve Bank are certainly executive activities, and the Constitution specifies there shall be only one executive branch, and the head of that branch is the President of the United States. In other words, the court cannot decide in favor of the president on this stuff. If they do, there are all kinds of implications that they don't want to embrace at this time. They don't want to see the executive taking over the Federal Reserve. Not these justices. Going on, and it is much more than an academic theory, rather it is operative way of thinking about and applying executive power that has had and will continue to have real-world consequences for our republic and for the international community. It sure will. If Trump gets to do this, we'll no longer have a republic. The mark of a republic is that the legislative branch can check the executive. How did the Roman Republic not become a republic anymore? When the Senate gave dictatorial powers to the triumvirate in Rome, and then eventually to Augustus Caesar. That's how the Republic ended. Barr makes no secret he adheres to the robust version. In an astonishing address that was delivered November 15th at the Federalist Society's annual Lawyers' Convention in Washington, D.C., he advanced a vision of virtually unchecked presidential power, attacking what he vaguely referred to as, quote, the left, unquote, for promoting a, quote, scorched earth, no holds war of resistance against the Trump administration. He contended that, quote, since the mid-60s, there has been a steady grinding down of the executive branch's authority that accelerated after Watergate. Bullshit. That is total bullshit. The low point of executive power was hit soon after Watergate, and executive power began increasing just a few years later when Ronald Reagan took power in the 1980s, and has been on continuous increase since that time. That is faulty history. Quote, the premise of the resistance is that the greatest danger of government but becoming oppressive arises from the prospect of executive excess. So there is a knee-jerk tendency to see the legislative and judicial branches as the good guys protecting society from a rapacious would-be autocrat. This prejudice is wrong-headed and atavistic. Well, it's fine to say that, but that's what the American Revolution was about. It was about getting rid of a tyrant who, by the way, was much more respectful of Parliament than Donald Trump is of the legislative branch of the United States government. Invoking the Founding Fathers, whom he maintained supported sweeping presidential powers. He lamented, Barr did, that many lawsuits that have been filed to block Trump administration policies, concluding that, quote, it is critical to our nation's future that we restore and preserve in their full vigor our founding principles. Not the least of these is the framers' vision of a strong, independent executive. That was part of the framers' vision. But the other part of it was that of the three branches of government, the first branch, intended to be the strongest branch, was the legislative branch. That's why its powers are given in Article 1 of the Constitution. All three branches were supposed to be strong, but the judicial branch was intended to be the weakest of the three. And by the way, the power of judicial review over the Constitution, which the judicial branch has asserted and made stick over a period of time, was not explicitly written into the Constitution. We recognize it now. And of course, these fundamentalists of the Federalist Society certainly want to defend that as much as they can. But at the same time, okay, if any of the branches was intended to be the weakest, it was the judicial branch, not the legislative branch. Barr's Justice Department will play the role, okay, of amicus curiae, friend of the court in the three financial records cases now pending before the Supreme Court, together with Trump's private attorneys. The Department of Justice will be well positioned to advance Barr's view on executive authority and his bare-knuckle defense of Trump in what is shaping up as a constitutional showdown for the ages. So just on these three cases alone, we're facing a constitutional crisis. But now, with the impeachment added to these three cases, and the possibility pending that the Congress will reply to Trump's defiance, that the House will reply to Trump's defiance, and to the Senate's defiance of its duty to provide a fair trial, that they will reply by issuing contempt of Congress citations to the members of the executive branch who are refusing to come and to testify. The possibility that they will do that then exacerbates this constitutional crisis. And whatever the Supreme Court decides in that respect is going to affect these other three cases that Bill Blum is talking about, and vice versa. What the Supreme Court decides in those three cases is going to have implications for whether or not this impeachment will go forward and how it will go forward. Now, why do I say that it's important that it's being held by the House? Because that holds something over Trump's head. If he continues to act, okay, let me take the prejudice away. Assuming, for the sake of argument, that he's right when it comes to the Ukraine, and he did not actually solicit any help from the Ukraine government to investigate a political rival in violation of the Constitution. For the sake of argument, let's assume he's right. He certainly has invited the Chinese to interfere. He certainly has invited the Ukraine interfere further. He may invite other governments to interfere with our electoral process. If he's vindicated by the Senate, he is all the more open to doing what he wants, to persuading people that he can do what he wants, but without formal vindication from the Senate. and with this impeachment hanging over his head, he has to think twice. He has to think twice before he proceeds with defiance of the House, before he proceeds with other offenses to interfere with the election. He has to think twice, because the House at any time can augment, can embellish the abuse of power article of impeachment and the obstruction of Congress article, and add other cases to them at any time. Not only that, if Pelosi wants, she can have the Judiciary Committee undertake a continuing process where it looks for other areas where the president has abused his power. And those other areas are out there in the open. They're being written by the press right now. What Nancy Pelosi did was to forbear and not include those other things in the impeachment indictment because she was seeking something quick and clean and easy to get impeachment out of the way. But once she realizes that her denying the Senate these papers can leave this hanging over Trump's head to serve as a check on his behavior during this election year, she may well decide not to transmit these papers. Now, I have felt for a long time that there is a clear and present danger which could arise out of the upcoming elections. And the danger comes from the fact that if Trump is fairly beaten at the polls, and all his efforts to suppress the vote in the coming election and to run an unfair election count for naught, and he does lose the candidate of the Democrats, who now I think is much more likely to be Bernie Sanders, and Bernie Sanders wins election, but whether it's Bernie Sanders, or somebody else, whoever it is, if they win election in the fall, Trump might just try to declare martial law. He might just try to retain control of the presidency through one means or some other to publicly overthrow the constitutional republic of the United States, just seize power as a dictator. If he were to do that, then it would be easy for Nancy Pelosi to release those papers. And there just might be enough of the Republicans in that kind of situation to say, okay, he's just gone too far, he's out, and complete the impeachment and conviction of Donald Trump right then and there, making him instantly no longer the President of the United States. The only way Trump can hold the presidency beyond November 3rd or 4th or 5th or however long it takes to resolve the election, the only way he can retain the presidency at that time is to give orders to the military, which he as commander-in-chief would still be able to issue. and which he can issue at any time between then and the inauguration of the new president. So, how do we stop that? How do we stop that from happening? How can it be stopped from happening? Well, it can be stopped instantly from happening if the announcement of impeachment is made to the Senate. The papers are sent over, the prosecutors are sent over. The Senate takes a quick vote to uphold the conviction, to uphold the impeachment by the House. And then at the stroke of the pen, at the entering of that result, that is the end of Donald John Trump as the President of the United States. No need to wait until January 20th. And having said that, now let me complete this article by Blum. Chief Justice Roberts and the other members of the nation's highest by judicial body up for the challenge. Are they prepared to demonstrate that there are no such things as, quote, Trump by judges, unquote? And Blum says, we'll have an answer by the end of June of 2020. So, by the end of June, we may also have an answer, as to whether the subpoenas that were sent over by the House to the staff, the 9 staff who would not come, and testify, whether those subpoenas can be enforced by the House. And once they are, the Trump administration is going to come down like a house of cards. Because once it's established that Congress does have proper oversight of the executive branch and can have the executive branch open to it, at that point, we are going to see evidence of so much abuse of power by this administration that it's going to be obvious to everybody, every Republican as well as every Democrat, that this president is guilty of obstruction of Congress and abuse of power. Let me finish this by calling attention to an article by Russ Feingold. Former Senator Russ Feingold of Wisconsin, who famously decided to run by clean campaigns with very little funding from the corporations, and who was beaten twice when he tried to go back to the Senate by the forces of money. He says, no one deciding to run for the U.S. Senate I picked this up in Reader Supported News. He published it in the Washington Post on the 19th of December. It was rerun, in Reader Supported News. And I'll put it on clearly. And he says, no one deciding to run for the U.S. Senate gives much thought to the Senate's role in impeachment. After all, before its The vote on Wednesday, the House of Representatives had impeached the president only twice since the nation's founding. But now the Senate will conduct a trial, okay, in order to determine whether President Trump will be removed from office. No proceeding in the Senate is more rare, and with the possible exception of voting on whether to declare war, no duty of a senator is more solemn or consequential. The Constitution specifically provides that when the Senate is trying an impeachment, senators, quote, shall be on oath or affirmation, unquote. Senate rules adopted in 1868 for the trial of President Andrew Johnson prescribe the oath that all senators will take, quote, to do impartial justice according to the Constitution and laws, unquote. That applies to Democrats and it applies to Republicans. As a senator from Wisconsin, I took the same oath in 1999 for the impeachment trial of President Bill Clinton. Taking the oath seriously led me to break with my party and oppose a motion to dismiss that would have ended the trial before the House managers had a chance to present the evidence they deemed to be most important. I also voted to permit the House managers to take new testimony from central witnesses in the case, including Monica Lewinsky. My view, both then and now, is that because senators have a singular role in impeachment proceedings under the Constitution, they must treat their responsibilities with utmost seriousness and care. This admonition applies equally to Democratic and Republican senators, regardless of how they may ultimately vote. That is why it was so troubling to hear the chairman of the Senate Judiciary Committee, Lindsey O. Graham, Republican of South Carolina, say recently, "I'm not trying to pretend to be a fair juror and to hear Senator McConnell say, quote, we'll be working in total coordination with the White House counsel's office," unquote. It is most certainly true the role of senators in an impeachment trial is not precisely to be jurors, quote unquote. Indeed, then Supreme Court Justice William H. Rehnquist ruled in the Clinton impeachment trial that, quote, the Senate is not simply a jury, it is a court in this case, unquote. Judges in court cases are not limited to the arguments made by the parties. They conduct their own research and evaluation of the applicable law. They issue rulings based on the totality of their experience and knowledge. Senators can and should do the same. The Constitution gives senators alone the responsibility to determine whether an abuse of presidential power has occurred and whether it is serious enough to warrant a removal from office. While the Chief Justice actually presides over the trial, he will not provide instructions for senators to follow in reaching their verdict, nor must their decisions be made in a vacuum, insulated from history and consideration of consequences. Indeed, I believe it is entirely appropriate for senators to consider the impact on the country of removing a president duly elected by the American people through the democratic process. Well, I want to quibble just a little bit there because I don't think that our elections are a democratic process. If they were a democratic process, Hillary Clinton, who, by the way, I couldn't stand either, would be the president of the United States right now. But judges, like jurors, are required to be impartial. And that is what the Senate impeachment oath requires. Working hand in glove with one side or the other as the trial proceeds is not consistent with that oath. And it is highly inappropriate for a senator to declare in advance that he or she cannot or will not be impartial in an impeachment trial. Not only highly inappropriate, it's in violation of the Constitution. It's a high crime and misdemeanor in itself. While Senate Republican leaders have been failing their constitutional responsibilities, their Democratic colleagues must remember to uphold them. As the trial approaches, Senate Democrats, including or perhaps especially those who are running for president, must be cautious in their comments. Oh, that many of them have expressed strong views about what the president has done and have urged the House to impeach the president. They are entitled, as political leaders, to express those views. But soon they will take the oath to do impartial justice. They must keep an open mind and consider the defense presented by the president and his attorneys before deciding whether to convict him. Comments from Senator Patrick J. Toomey this past weekend offered a reassuring contrast to those of his party leaders. Quote, I think it would be extremely inappropriate to put a bullet in this thing immediately when it comes over. I think we ought to hear what the House impeachment, what the managers have to say, give the president's attorneys an opportunity to make the defense, and then make a decision about whether and to what extent it would go forward from there. Unquote. All senators should heed his words. Whatever the one thinks of the Clinton impeachment 20 years ago, the trial in the Senate is generally seen as having been fair. How the Senate handles this impeachment trial will not only determine whether Trump completes his term, it will also set important guideposts for the future of this very rarely needed but still crucial constitutional remedy for abuse of power. Senators would do well to keep that in mind as they prepare for the upcoming trial. History will not look kindly upon them if they don't. Not only that, but a dangerous precedent would be established. Consider the following scenario. Let us say that a Democratic president gets elected in 2000, okay, and 21, and then wins a second term in 2000, okay, in 24, okay, and then finds he has a Senate which is run by his party, but has a House that is now a Republican House. And that House now wants to block his program for the second term in every important respect. They want to put in absolute resistance to this program, and they proceed to impeach the president. And the case then goes to the Senate. If that occurs, it should be clear to the Republicans that they then will want a Democratic Senate to take their charges seriously and to have a fair impeachment trial at that time. And if the president is convicted, then so be it. But if not, then so be that. The point is, there are advantages of impartiality for both sides. That needs to be recognized. The longer term interest of stability needs to be recognized here. The institutional integrity of the Senate needs to be taken seriously here. All the people who run the Senate say they love that institution. All the long term senators in the Senate say they love the institution. Now is the time for Mitch McConnell to prove that he loves the institution, and Lindsey Graham as well, and all the other Republican senators who are determined to be biased and to slant this towards Trump. They have to stop and open their minds and open their hearts to the need to protect the institution that they claim to love so well, and to protect the Constitution that they have sworn an oath to serve. So let's cut the crap. And let's get on with serving the Constitution for a change and not serving the frickin' donors. Okay, so that's my piece for tonight. I hope you liked it. I see some 9 of you are still here. That must mean you liked it because I've been on for a long time. Please share, like, and subscribe when this goes up, okay, on YouTube. And please share the hell out of it, okay, on Facebook as well. And please become a patron at www.patreon.com/Joe_Firestone. And now I'm going to go back to I'm going to go to your comments on Facebook. Steve Wolfbrand, forget impeachment. Just elect Bernie Sanders. Steve, I wish it were as simple as that. But what makes you think that election is going to be respected and will be definitive? And that Bernie Sanders will take office on January 21st of 2021 as planned. By the way, Kay joined, Dale joined, Jim Bird joined. Okay. I mean, you don't know that's going to be the case. There needs to be protections against a possible coup from Donald Trump. Cheyenne says, my problem with this farce is that it should have begun the first time he violated the Constitution. Pence will be no picnic either. Pence is not going to seize control of the Republic. There's no evidence of that in any of his behavior prior to this time, and he has had a long career in the Congress. There is no indication that he would overturn the prerogatives of the Congress. I don't believe he will. He's not that kind of personality. He doesn't have the charisma, okay? He doesn't have the drive. He doesn't have the ability to move people. Okay. Anyway, Cheyenne, your problem is certainly a valid problem to have had. But the question is, what are we going to do now? It should have begun the first time, on the first day. In a way, it did, or soon after, when Al Green tried to file articles of impeachment, which were based on the Emoluments Clause. He did that right at the beginning, but Pelosi would have none of it. There were Democrats who tried to do this earlier, but Nancy Pelosi was in charge and she forbade it. So now we have it. What are we going to do now? We have to act from this point forward. We can't be looking at the past. In other words, the problem with the farce does not delegitimize the process. It does not actually delegitimize the Constitution. The ability to impeach is there. The duty to impeach is there. Because there is a danger that he won't leave. Steve says, Los Angeles is Bernie crazy. We're on fire here. AOC is right. We have art, Bernie bus, chalk art, dancing. The revolution is beautiful. Yes, it is. And Kay says, Pence is just as guilty as the orange idiot. Yeah, he may be just as guilty, Kay, as the orange idiot. But that doesn't mean that he won't be a caretaker for a few months. He can be a caretaker for a few months. He's not going to try anything. He can't call out those masses that Trump can. Steve comments, okay, that revolution is fun there. And Kay says, hey, Dolores, didn't see you here. Hey, Dolores, I didn't see you here either. And Steve says, forget it, Doc. We have an election coming. Let's concentrate on that. We have to do both at the same time. We have an election coming. Just last time, what was my live stream about? Just last night. It was about the debates and who won. I thought that was important enough to concentrate on that at that time. Tonight, I went to the impeachment again because I think the point has to be made that the fact that there was an impeachment has produced something that can be held over the head of Trump and that can put a block in his way of continuing to defy the Constitution. Steve says impeachment distracts, okay, from our revolution. It doesn't distract. Does it distract you? Does favoring impeachment distract you from favoring the revolution? Does it distract me? No. We can walk and chew gum at the same time. It's distraction only if we allow it to be a distraction. Kay says, I'm getting sick of all the impeachment stuff too. The Senate isn't going to be fair anyway. Glad I can hear and see Bernie rallies almost every day. At least they give me some hope. I understand the sentiment, Kay, but also, we can't afford to be sick of the impeachment stuff. Yeah, the Senate isn't going to be completely fair anyway. But if they take those oaths, there will be some of them who will be more careful than others to try to uphold them. All that's needed in the Senate is a fair trial with witnesses being produced and forced to answer questions from the House managers, from the prosecution, forced into cross-examination. That's going to produce something else to add to the case of the House. It will produce things that the House can use to bind Trump, to check Trump. As we move into the election season, we need those bounds. We need that binding. We need him to be preoccupied. We need him to visualize that there may be a penalty for voter suppression or rigging the election or using foreign powers to help to secure his election. Steve says, love you, Doc, but you're not always right. I know I'm not always right, Steve, but guess what? I'm right about this. You got to have enough energy to do both. I do. Why don't you? Kay says, laugh out loud. GOP don't give a damn about the Bible unless it interferes with a woman's right to choose. Nice one, Kay. I agree that generally they don't care about the Bible. But you know what? Some of them do care somewhat about the Constitution. Some of them do care somewhat about the fact that we're not a dictatorship, that we are a republic, Even if they want, okay, an oligarchy. An oligarchy is not the same thing as a dictatorship. They're part of the oligarchy. They don't want a president arbitrarily deciding whether they live or die, or whether their property gets snatched or doesn't get snatched. They don't want a Mussolini in a position to determine their fate. They want to have a say over their fate. And Mr. Mussolini, now in the White House, won't stop. He won't stop until he has total power. They're going to have to decide to stop them at some point. This impeachment, Steve says, this impeachment is a shit show meant to distract you. Meanwhile, we have a revolution to do. Stop, Doc. No, Steve, I'm not going to stop. This impeachment is not just a distraction, because as I explained, Trump will have, after the election, he'll have the rest of November, December, and January to put together a coup plot. And he will be the president. And he will be the commander in chief during that time. So who will stop him? What are you going to say then, Steve? Are you going to say Trump wouldn't dare deny the results of the election? Are you really serious about that? Do you believe in Santa Claus too? Kay says, lots of people at the Bernie rally in Vegas tonight I just saw. Go Bernie. Go Bernie is right. Subpoena Biden and Hunter. I don't care if they subpoena Biden and Hunter. Let them subpoena Biden and Hunter. Hunter smokes crack with hookers with dildos. He's not, I don't think he's making the 50,000 a month anymore, Steve. I'm not in favor of Biden. Look, it might be a very good idea. What exculpate means is that the evidence tends to show the innocence, okay, of the accused. Okay, that's what Lana asks. Steve says apply dildos. Good. Investigate Biden. Great. I mean, the defense witnesses for Donald Trump, okay, or the defense managers for Donald Trump in the Senate are likely to call Biden and maybe Hunter Biden. Lana says, boo Larry Tribe, okay, for being a centrist. I don't doubt, okay, his constitutional knowledge. Actually, Larry Tribe is generally considered to be pretty much on the left of constitutional scholars. He is not a centrist, not in the realm of judicial scholarship. Okay. By the way, he thought the platinum coin was perfectly constitutional. And Steve says, unforgive or uncharge. Kay said, had to go check in with the Bernie Vegas rally. I love the hope it gives me. Very little hope to come by in my life these days. Mad Hildebrand has joined. Hey, Mad. Still mad? And Kay says, nothing happens to the orange idiot. He's become a fascist dictator thanks to the GOP Senate. Okay, a comment from Evelina Pont. Hi, Evelina. Why are some of the Dems who voted to impeach Trump the same ones who agreed to give him more money for defense and the war? Separate things, maybe, but they're conscientiously different things. I don't think they're separate things. I don't think they should have agreed to give him any more money for the war, okay, and for the wall. And I don't think they should have given him his trade deal. I think they should be holding out for a better trade deal. I mean, look, I think the Democrats are terrible. Nothing what I'm saying here is holding a brief for what these silly Democrats have done. They should have had him impeached long ago. They should have started him impeaching him in January of 2019. It would have been all done by the end of 2000. I'm sorry, by June of 2019. Wouldn't have gone longer than 6 months. I mean, these people are terrible. I'm not holding a brief for them at all. But the question is, we're here now. Where do we go now? If we just forget about impeachment and give Trump a chance to say he's been vindicated, we are removing an important potential control over Trump. And we should not do that. We need that constraint. We need his lawyers telling him, be careful. The impeachment indictment is still out there. You haven't been vindicated. Watch what you do. You don't have free reign yet, Donald. We need Barr telling him that. Barr will tell him that. Kay says, double ugh for me, Evelina. Lost the only real job I ever had working at the old state mental hospital on the male crisis ward back in 1982. Okay, Evelina says, Kay, I remember when he fired all those air controllers. Yeah, I know. That was complete madness, too. Actually, I think Reagan should have been impeached right then and there. And Kay says, yep, it turns out I was pretty good with crazy men. Laugh out loud. First hubby was good practice. Laugh out loud. Joke. I was 5 feet tall and 100 pounds, and we had 25 to 35 men there at all times. I treated them all like friends, and we got along fine. I lost my job when the hospital was closed, but two of my guys killed themselves rather than be transferred to somewhere they knew would be good. One jumped from the huge water tower there, and the other hung himself on the transfer ward. Oh, that's terrible. Guess they weren't watching him too closely. SMH. Case, Evelina says, you sound pretty amazing. Kay says, thank you, Evelina. I'm a low-wage retiree now on $600 a month, Social Security, and very little hope. I had some stories to tell, but none of the things I did are helping me now. Bernie is my only hope to have a life worth living at my old age. There are many of us in that same boat, Kay, and okay, I agree that Bernie is our only hope and our children's only hope for the future as well, and our grandchildren's only hope. He is the only hope. So let's do what we have to do to make sure that he not only wins the election, but that his victory can be made to stick. And if Trump is in office on November 3rd, I think there is doubt about that. I think there is doubt about that. And we have a chance to remove that doubt. I say we. The Congress has a chance to remove that doubt. If they will hold this over the head of Trump for long enough, and if we can get enough pressure on the Republican senators for them to begin to consider him a liability in a November election, threatening their seats, we've got to make them want to replace him with Pence. So, okay, guys, I see you're thinking it's time to go to bed. Okay. Evelina says, you're right about the impeachment, Dr. Joe, even if we resist you. Well, thank you, Evelina. I certainly appreciate that. But I expected some resistance on that because everybody on the left is saying, forget about impeachment, let's just do the election. Forget about impeachment, let's just do the election. And everybody is saying it. I mean, Jamarl Thomas, okay, is saying it. Nico House is saying it. The Rising is saying it. Tim Black is saying it. Kyle Kulinski is saying it. I mean, all the people I pay real attention to are saying it. Well, let them tell me. How do we stop Trump from staying in office beyond November 3rd if we're successful in this election? How do we do that? Well, we can eventually all go into the streets, and maybe we'll be successful at going into the streets. But if that impeachment is still hanging over his head at this time, then maybe the Senate will listen then. Right? We need that club. We need that club. Nancy Blackmar's here. Hi, Nancy. And Sabrina Alessandrini is also here. And welcome to you, Sabrina. Okay, folks, I've been on for ages now, about 2 hours and 15 minutes, and we're down to 6 folks. So I'm going to say goodnight. Thank you for coming. Thank you for giving me a good discussion. Thank you for giving me an argument. Okay, I live for arguments. So thank you, everybody. And I'll see you on Monday night at roughly 9 o'clock. Hi, Andrew. Thank you for coming, by the way. It's nice to see you here every once in a while. Kay points out Ro Khanna didn't vote for that. No, he didn't. And he gave them all hell on the floor for them for doing it. Yes, he called it an immoral act, as did Bernie. He's co-chair for Bernie's campaign. He is. He is. He is. He is. Okay, I'm going to say good night, folks, and I'll see you on Monday night. And again, thanks for coming.